Hi, I'm Marie Giannacopoulos and I'm an Associate Professor of Criminology at the University of New South Wales, where I also direct the Centre for Crime, Law and Justice. I'm also the author of Chapter 8 of the handbook, and it's titled Laws, Violence, the Police Killing of Kumanjayi Walker and the Trial of Zachary Rolfe. My chapter tackles the problem of how law is ordinarily understood. Law in a colonial context is a form of violence, but this is a mostly hidden feature of colonial law, Law is also not singular, as there are other forms of law that are covered over by the operations of colonial law. When we see law in this way, we can begin to better understand the role of law in police killings of Aboriginal people and the way that the judicial system works to cleanse that violence. How was my research inspired? Through the continual questioning of the singularity of law, and that's something that I've been able to do and continue to do across the body of my work, because of the influence and role played by Indigenous thinkers in my own thinking, in particular the work of Professor Irene Watson, who is a prolific and leading scholar in assisting us to understand the coloniality of clearly the coloniality of law and the way that it effaces laws and sovereignties of First Nations peoples. So how did I go about my research? A few years ago, I read an interview between Irene Watson and Isabel Coe, and I became fascinated by the Nuyirima challenge. This is a case where Aboriginal people brought a case within the colonial system, within the colonial judicial system, to have the crime of genocide recognised. This couldn't be recognised by the colonial court, but the interactions between Isabel Coe and her comrades and the court are very revealing about the limits and the blocks that are experienced by Aboriginal people when they turn to law for what we might think of as looking for decolonial justice, but through the colonial framework. It's an impasse, it's a block. So my research approach was to read that judgment, the transcript of the proceedings, and to proceed to connect that form of protest with the conceptualizations of colonial law by Indigenous scholars, and finally to use that to analyze state violence. What are my key conclusions and findings? That Australian law, that is settler colonial law, is violent, but this is invisible and unpalpable to those who are not the direct targets of this violence. Law's violence is not a purely philosophical question. In settler colonial contexts where structures of law provide unlawful and non-consensual foundations for the maintenance of colonial power, it is absolutely necessary for us to explore the question of law's violence with attention to the colonial infrastructure that it provides. By positioning the police killing of Kumanjayi Walker and the subsequent acquittal of the police officer who killed him in relation to the Nuyirima challenge, the killing function, or what I call the nomicide or death by law, can be laid bare. I hope you enjoy the chapter. Thank you.